So without further ado, should we get cracking, Conor?
Let's.
There we go. That's what we're going to talk about. Jurisdiction first. And the thing to remember about road traffic accidents is that there is a really stark distinction between European cases and non-European cases. So if you have a traffic accident that occurred somewhere within Europe, there is a completely different framework in relation to jurisdiction as opposed to those accidents which occur outside Europe. So it's really, really important to bear that in mind. The second thing that it's really helpful to bear in mind, I always think, is that there is a distinction between jurisdiction and applicable law. So you're considering jurisdiction as one whole and entire issue of itself, and applicable law as another issue of itself. And the reason for that will become apparent as we go through, and it's that quite often, particularly in the European cases, the courts of England and Wales are going to have jurisdiction, but they're not going to be applying English law to a case. So jurisdiction and applicable law are conceptually totally different. Some district judges still haven't got the memo on that. So you do occasionally get a case where the judges send out, of their own motion, send out an order that says, well, if English courts have jurisdiction over it, it must be English law. Or alternatively, if it's a foreign accident, then we can't possibly have jurisdiction over it. The thing to do with that is to get the defendant on board and write jointly to the court and say, well, actually, you do have jurisdiction for this reason, but this is the applicable law for this reason. And some courts are more willing to take that on board than others, I find. But first things first, jurisdiction, European cases, the tortfeasor themselves, so the person who is responsible for the traffic accident, who you would normally sue if it were an English road traffic accident, the English courts will not have jurisdiction over the tortfeasor under Article 4 of Recast Brussels because they're going to be domiciled abroad. So subject to this regulation, persons domiciled in a member state shall, whatever their nationality, be sued in the courts of that member state. So if you have an English client who goes abroad to, say, Spain, and they're in a car crash with a Spanish driver, the courts of England and Wales are not going to have jurisdiction over that driver on his own. So you need to find a way of bringing the accident within the jurisdiction of England and Wales. And this is the way to do it. You sue the insurer. I won't go into the ins and outs of FBTO and Odenbright because we don't have time to do that because we're trying to deal with so much stuff at the same time. Suffice to say that following FBTO and looking at Section 3 of Recast Brussels 1, which I also won't go into, the claimant can sue a road traffic insurer directly if there is a direct cause of action against the insurer. What does that mean? It means that you can bring a claim against the road traffic insurer within the courts of England and Wales, because that's our claimant's home courts, only where there's a direct cause of action against that insurer. And in road traffic cases, there will be a direct right of action against the road traffic insurer by operation of the 6th Motor Insurance Directive. So this is where European law is really, really important and advantageous to us, because the 6th Motor Insurance Directive told member states of the European Union that they had to provide for a direct cause of action against the insurer. Ironically, England is or the UK is the only member state that didn't actually implement that properly. But we don't have to worry about that because we would have jurisdiction over English road traffic accidents in any event. So where you have a motor insurer, and it specifically only relates to motor insurers, but where you have a motor insurer, there will be a direct right of action, almost certainly, so 99.9% certainly, in any other European member state. So you sue the motor insurer directly, which is why you have claims where you've got an individual, your client, if you're acting for a claimant, suing Allianz or Generali, but not suing the tortfeasor. Some road traffic insurers, and particularly MAPFRE and other Spanish insurers, have territorial limitation clauses in their contracts. So in their insurance contract with their insured, the contract will say that they are only liable to indemnify in respect of claims which are brought within the Spanish courts. That was something that gave rise to quite a lot of difficulty, and it's something that was quite controversial. It's quite controversial even within Spain as to whether or not you can do that, because you're limiting the claimant's jurisdictional options. So whether or not that was consonant with European law was something that was quite controversial in Spain. It's also noteworthy that that sort of clause has to be specifically accepted by the insured, which means that the tortfeasor would have had to accept a territorial limitation clause. It would have had to have been brought to his attention. He'd have had to sign off on it quite literally. There was a lot of case law around that, but this has really come to an end after this case of Hutchinson and Mapfre this year, where the judge found that it wasn't consonant with European law for there to be a territorial limitation clause, which means that now in cases where Mapfre and other insurers are arguing that they shouldn't have to respond to a claim within England and Wales because their indemnity is limited by this clause, that's not going to work unless, of course, Hutchinson is appealed and we see a development there. But other than that, territorial limitation clauses are now a thing of the past. So you can sue the insurer. You could also sue the tortfeasor as well. I'm often asked, well, okay, so we can bring a claim within England and Wales against the motor insurer directly. Shall we also sue the tortfeasor as well? And unless there's some particular feature that makes that desirable, I usually say, well, no, don't bother doing that. The reason being that the tortfeasor would have to be served within his own domicile. And that's just a real pain, because it means you've got to translate proceedings, you've got to get the foreign process section involved, and there will be delay and there'll be additional cost. And there's no real value to that, because if you've got a claim against his insurer, in any event, you don't need to sue the tortfeasor as well, because you can serve the insurer via the English claims handler, and there must be an English claims handling agent under the motor directives. So you can, following this case, which I won't attempt to pronounce, the European Court of Justice case, you serve on the claims handling agent, and that is good service. So all you have to do is serve your proceedings within the jurisdiction on the claims handling agent. That means you have 4 months rather than 6 to serve, because you're serving within the jurisdiction. But it does mean you don't need to go through all the motions that you would have to do otherwise if you're serving abroad. If, however, the insurer has nominated solicitors within the jurisdiction, you must serve on those solicitors. So you've got a choice of either serving the handling agent, or if the insurer has nominated a solicitor, you have to serve on that solicitor. So just bear that in mind, because occasionally you get a situation where insurer has nominated, but the particulars have been served on the handling agent, and that's not good enough. So service within Europe is easy peasy as a result of operation of the motor directives. Now, jurisdiction outside Europe is much more complicated. And I don't think there's anyone working within our industry who isn't aware of the case of Brownlee, which we'll come to in a little bit later. But Brownlee is a really great demonstration of how this type of litigation can go on for years and apparently without end. And I was asked by Claire Campbell the question about whether or not Brexit would ever come to an end. Brexit's never going to come to an end, and the case of Brownlee is never going to come to an end, it would appear. There are so many interlocutory hearings in Brownlee that it's really hard to imagine that there will ever be an end to it. And the reason for that is that the accident happened outside Europe. The rules governing accidents taking place outside Europe are much, much more difficult, complicated, and it's much harder to get the English courts to take jurisdiction. The rules within Europe are very straightforward, because you either have jurisdiction or you don't. The rules outside Europe are much more difficult, because you have to come within a jurisdictional gateway, and then there are other rules as well. So the first thing you need to ensure is that your road traffic accident falls within one of the jurisdictional gateways. And these are to be found, as I say, in CPR Part 6, Practice Direction 6B. So the ones that are most important for us are that damage has been or will be sustained within the jurisdiction. That's quite easy to satisfy for us, because if you've got an English claimant, they will probably still be suffering ongoing symptoms within this jurisdiction after they get back. If they're not suffering ongoing symptoms, it's probably not worth bringing a claim against a defendant who's outside Europe in any event, because it's difficult. The other possibility is that you've got an anchor defendant. So you've got an English defendant, and then you want to bring someone in from abroad who is a necessary or proper party to the claim. So that's an additional claim, a Part 20 claim, or an additional defendant, where that defendant is a necessary or proper party, i.e. the same cause of action, the same accident, the same facts. So the jurisdictional gateways, as far as foreign road traffic accidents are concerned, are actually not that hard to get through now. So it's, for example, they'll suffer injury, ongoing injury in the jurisdiction, or there's been care provided within the jurisdiction, or there's been medical treatment provided within the jurisdiction. So those, once you've got through the gateway, you then, or once notionally in your mind you've got through the gateway, you then have to consider the other rules and the other aspects that you have to satisfy in order to establish jurisdiction against a defendant in a non-European road traffic case. So you've got to apply for permission to serve the claim form, and the claim, first of all, has to be able to pass through one of the gateways that we've just examined. The claimant must say in the witness statement, or you must say in the witness statement, the claimant believes the claim has a reasonable prospect of success. Claims ought to always have a reasonable prospect of success, otherwise why are you bringing them? So that's fine. And the court must be satisfied that this is the proper place in which to bring the claim. That may be more difficult because you're talking about an accident by definition that hasn't happened in England and Wales. You're talking about a defendant by definition who isn't within England and Wales. And therefore you're talking about an accident happened, as in Brownlee in Egypt, against a defendant where in Brownlee it was very difficult to establish where that defendant was, but certainly the accident was in Egypt and the immediate surroundings of it was in Egypt. In that case, in Brownlee, Lady Brownlee's husband had been killed in the accident. She had a Fatal Accidents Act claim. And so the damage was effectively, all of the damage was incurred in England and Wales. And in Brownlee, the Court of Appeal has found that the English courts are the proper forum in which to bring these proceedings. But you can see from the fact that there is a 2018 reference, which was the Supreme Court, and a 2020 reference in Brownlee, that it has taken many years to reach that point with Brownlee. And the issue with this is that whether or not the courts of England and Wales are the proper place in which to bring the claim is quite a difficult one. And it involves a balancing act of where are the witnesses? Can the claimant give instructions properly abroad? Can the claimant move to abroad in order to attend the trial? And so on and so forth. What applicable law is going to be applied by the courts seems to be a less important factor in all of that. It's more the logistical factors. In some cases, particularly in India, Pakistan, places like that, you can argue that the English courts are the best place in which to bring the claim because there would be such huge delay in those foreign jurisdictions. And I've seen evidence from Indian lawyers that on average it takes 10 years for a case to go through the Indian courts, and therefore it's more appropriate for the claim to be heard in England. What's happened in the case of Brownlee itself is an argument against that, because it takes us ages and ages to deal with some of these claims as well. So quite how smug we can be about being faster and more efficient than some foreign courts, particularly when you see that the Greek courts have managed to deal with Harry Maguire sort of within about 5 minutes of the alleged offence taking place, I'm not sure. But that is an argument that has been deployed, can be deployed. So in terms of jurisdiction outside Europe, it is a balancing act as to whether the courts will accept jurisdiction or not. Now, once you've got your permission to serve outside Europe, how do you do it? The court will give directions for service, so it will tell you how to do it. And that's something you should be thinking about before you're even applying for permission to serve outside. Because if you can't serve your proceedings outside Europe, there is no point bringing the claim. Because in order for a claim to get off the ground, you've got to serve it. And that means that you need to think about service before you even start applying for permission to serve outside. When you are applying for permission to serve outside, the court ought to give you directions for service and ought to give a direction as to timeframes within which the defence has to be filed. I think the safest thing to do is always to serve via the foreign process section. And the reason for that is that it means that if anything goes wrong, it's not your fault. Because if you send your proceedings properly to the foreign process section, and they're really, really helpful, they'll tell you what you need to send, they just deal with it. There is an enormous backlog at the moment because the foreign process section was shut for, I think, 2 months. They already had a backlog, and because of COVID-19, they're kind of running at half strength, and they've got a backlog because they were shut. I spoke to a nice man in the foreign process section the other day on the telephone about a case that I have, and he was pretty much on the brink of a nervous breakdown as far as I could gather. So please don't shout at the foreign process section. They are doing their best to get things served. But it does mean that it is often taking more than the 6-month lifetime of the claim form to serve via the foreign process section. So you need to be ready to make an application for an extension of the lifetime of the claim form. If you do not do that within the lifetime of the claim form, it puts us in a really, really difficult position. I've had half a dozen of these lately as a result of COVID-19, I think. And it is very, very hard to persuade a court that there was some good reason as to why you didn't apply within the lifetime of the claim form for an extension of it. So if you are using the foreign process section, you can't just send it to the foreign process section and then forget about it. You do need to diarise and make an application probably about 4 months in. The other thing to remember about the foreign process section is, I'm terribly distracted by Boris now. The other thing to remember about the foreign process section is that you need to send your proceedings to the foreign process section in good time. So judges are very, very unimpressed if you take 5.5 months to send your proceedings to the foreign process section and then say, well, they haven't managed to serve them, because the judge will say, well, they ought to have had 6 months to do it, but now they've only got 10 days to do it. So of course they couldn't do it. And there has to be a reason as to why you've done that. And actually quite a lot of these are a combination of Brexit and COVID-19. So I do have to mention Brexit actually, because we all issued before the Brexit deadline, and now we're having to serve everything all at the same time, and with COVID-19. So it's something of a perfect storm, and I do accept that, and judges accept that too. Bringing me on to Brexit, will the uncertainty ever end? This is Claire Campbell's question. No, the answer is no. The uncertainty will never end. What seems to be happening at the moment, and it's a real rollercoaster Brexit, and we've been predicting things for the last couple of years, and I've heard lots of predictions about what's going to happen with Brexit, and there were lots of webinars on Brexit and what's going to happen and how to prepare for it and all the rest of it. The truth of the matter is that none of us knows, and we never have done. And to the extent that any of us have been trying to spout some kind of crystal ball gazing about what will happen with Brexit, what will happen with transition, what will happen once we've transitioned, none of us have the faintest idea. That's the truth of it. And we still don't. So as of today, I can say it looks as if it's going to be a no deal. And the reason it looks as if there's going to be a no deal is that Barnier is making very pessimistic noises. Angela Merkel's just taken Brexit off the agenda for their trade talks. And Boris is Borising. So it looks as if we're not going to reach a deal. The result of that could be that all of those cases that I was talking about where it was easy peasy because all you had to do was bring yourself within the various jurisdictional rules and all you had to do was serve within the jurisdiction on the claims handling agents, all of those cases are going to be shunted into the outside Europe type of case. Because if there is no deal and if the talks break down completely, we may end up with a situation where the courts of England and Wales do not have jurisdiction over European road traffic accident cases unless you can bring yourself within the gateways and the forum conveniens and all the rest of it that I've been discussing with the outside Europe cases. And so it seems to me that is unthinkable. And not just unthinkable because the government really cares about personal injury claims, they don't. It's unthinkable because the government cares about commercial claims. And there will be a lot of lobbying before the end of the year from the people who really count, the people who bring money in via their legal shenanigans. And it's not us. They're not interested in personal injury claims as such. They're interested in the big corporate business claims against each other, and they will want to sort out jurisdiction. And we, as a sort of sideshow to that, may well be brought within any deal that occurs as a result of that. So I think the uncertainty is not going to end until the end of the year and probably beyond. But anyone who makes predictions about what's going to happen with Brexit is a fool. And I've just made one, so I must be one. On that note, Conor, I will hand over to you on applicable law. I'm sorry it's such a real gallop through things, but there's loads to cover, including the MIB.
Okay, so applicable law set out in Article 4 of Rome 2, which essentially standardised the rules within the EU about well, non-contractual obligations, also commercial obligations, but so far as we're concerned with road traffic accidents, essentially torts. So an SLR is provided for. The law applicable to a tort is the law in which the damage occurs, irrespective of the country in which the event giving rise to damage occurred. So I think that's a reference to product liability cases. In road traffic accidents, obviously the damage is going to be the car crash. So if it's a crash in Spain, then Spanish law will apply. In France, French law will apply, and so on. Article 4.2, however, where the person claimed to be liable and the person sustaining damage both have their habitual residence in the same country at the time when the damage occurs, the law of that country shall apply. So this is a case where, for example, you have on the Costa del Sol, 2 English drivers, a road traffic accident, and the claimant and defendant both have their habitual residence in England, then English law will apply in that case. 4.3, where it's clear from all the circumstances of the case that the tort is manifestly more closely connected with a country other than that indicated in 1 or 2, the law of that other country shall apply. A manifestly closer connection with another country might be based on, in particular, on a pre-existing relationship between the parties, such as contract. So this is probably most significant in travel claims where there's a sort of package holiday contract in place, probably not so significant in road traffic accidents. So applicable law governs substance but not procedure. That's liability, the question of liability. So French law or Spanish law will determine that. Contributory negligence, it's important to remember that in a lot of legal systems, the concept of contributory negligence isn't recognised as a defence. So although we have it here in England, it's something that you won't necessarily find in other countries, depending on the jurisdiction. And quantum, including what you sometimes see in other jurisdictions, indemnity limits and caps on compensation. The other important point to note is that limitation is considered a matter of substantive law, something I'll give a little bit of detail about later, but it's quite a trap sometimes, because in Switzerland, for example, you've got a 1-year limitation claim subject to certain exceptions. In some countries, you've got 2- and 5-year limitations, depending on whether you're claiming against the insurer or the tortfeasor. So it's just something to be on guard. If you think that English procedure will apply and limitation is a procedural matter, that could be a trap that could catch claimants out. Then procedure is questions of evidence. So there's the case there of Wall and Mutual. I don't know, Richard, it's an old case, but it's a very important and interesting case. Richard Collier and a solicitor he works with have written an article on this on our website, which you can see. And it's a very entertaining article about Richard's love of reading case law. But essentially, it can sound quite straightforward. That of course English judges will apply English rules of evidence because we're not familiar with the different more interventionist judicial approaches that you'll have in Germany and so on, and France. It would just be a nightmare to expect English judges to do that. But where you can have some difficulties, as Richard points out in his articles, and Mike Hagan, is when you're asking a French lawyer to give expert evidence about French law on quantum. But in fact, in France, that's not the way it works. The French lawyer won't actually usually give a recommendation of a figure for quantum. They will do that in tandem with a medical expert. And obviously, when you're getting expert evidence of French law, you just want a French lawyer to sort of give you a rough idea of what it's worth without bringing in a further medical expert as well. So it can be quite difficult in practice. And then also costs are a matter of procedure. And then I've said, note recital 33 to Rome 2. According to the current national rules on compensation, when quantifying damages for personal injury in cases in which the accident takes place in a foreign state, the court should take into account all the relevant circumstances of the specific victim, including the actual losses and costs of aftercare and medical attention. So this is a kind of to catch claimants who are perhaps hard done by if they've got huge medical bills back in England, because perhaps our NHS isn't as well run as other public health systems where, such as, let's say Germany, for example, where Germany might not might not allow damages for medical loss because they have a better health system that can act more promptly to give people operations that they might need. I'm not sure to what extent that would also allow, for example, an investment banker to recover particularly high loss of earnings, but that's something that, you know, I think is probably arguable. Other points, very briefly, on applicable law. Foreign law is a matter of fact. You will need expert evidence to prove it. In the absence of that, the presumption is that English law would represent the law. And then there's the note that I mentioned about differing limitation periods. I've just given some examples of them because I couldn't list them all here, but in Italy, you've got 2 years in road traffic accidents as opposed to a different limitation period for different torts. Denmark and Greece, you've got 5 years against the tortfeasor, but 2 years against the insurer. Turkey, you've got 1 year flat. And Spain, you've got 1 year from the conclusion of criminal proceedings, or if there are no criminal proceedings, from the conclusion of the investigation. So to summarise what Sarah and I have said on jurisdiction and applicable law, English courts have jurisdiction over European traffic accidents, unlikely to have jurisdiction over non-European traffic accidents unless there's some sort of exceptional feature. In terms of applicable law, that's likely to be a place where the accident occurred, the law of that place, but there are some exceptions where it's more particularly suited to have English law applied, and that there's a distinction between substantive issues and procedural issues. The claims against the Motor Insurers Bureau, we've got to the exciting part of the talk. So there are various EU motor insurance directives which require insurers to cooperate to handle claims between different states. And victims can claim where their representative fails to respond to a claim promptly. So there might be an insurer, but they don't respond. The other cases, of course, are where the vehicle is simply not insured, or where there's been some sort of hit and run and the vehicle can't be traced. So in the UK, you'll be familiar with the, sorry, I've got a question from Chris Conor. Do the motor directives apply to cyclists, pedestrians, as well as car drivers? It would apply, so essentially, yes, the vehicle and the tortfeasor have to be insured. So whether they injure a victim who's in a car or a pedestrian or a cyclist, it doesn't matter. They're all entitled to the benefit of this insurance coverage. So the MIB is the compensation body for these claims, and so, you know, different states are now obliged to have these compensation body, and our MIB fulfills that role within the UK. And when it's acting in that role, it operates pursuant to these 2003 regs, these Motor Vehicle Compulsory Insurance Information Centre regulations. And these allow an injured party to receive compensation from the MIB if they're a UK habitual resident. And then the MIB will then recover its compensation from its counterparts in other member states. I won't go into that too much because obviously the MIB will sort that out between itself and the other bodies. Alistair Kinley has a question, I think. I raised his hand. So Regulation 11 of these 2013 regs, or 2003 regs. So these are two separate situations. First one we're looking at is Reg 11 and 12 are where we know that there is an insurer, and Reg 13 deals with uninsured or you can't trace the vehicle. So starting with where there is an insurer, Regulation 11, where the insurer can be identified. So even if there is an insurer that can be identified, the victim's entitled to compensation from the MIB, where there are, and here's unfortunately just a very long, tedious list of criteria. Resident in the UK, and I have to say I've summarised this. The actual wording is more sort of verbose, and you can find it in the 2003 regs online. But briefly, they have to be resident in the UK. The claims they have to claim to be entitled to compensation for an accident occurring in another European Economic Area country, and the loss has to be caused by a vehicle based in another EEA state and insured in another EEA state. and they have to meet the following conditions. So the victim has claimed compensation, and neither the insurer nor a claims representative have applied within 3 months. And secondly, the insurer has failed to appoint a claims representative in the UK. So we've got a question here from Wayne Barrett. In Greece, if you pursue the tortfeasor after the 2 years, but within 5, I presume the insurer will not indemnify due to it being outside the period of limitation. It's going to be a question of Greek law, but I think that would be right. So then you'd have to get into that messy business that Sarah was talking about earlier, where you're going to have to serve on the tortfeasor abroad, and it's going to be quite complex. And obviously, you're also going to have to risk that the tortfeasor doesn't have any money. So Regulation 12, the response from the compensation body, so that's the MIB in the UK. The MIB shall respond to a claim for compensation within 2 months. If a victim satisfies the MIB as to the matters in the next paragraph, which we're about to look at, then the MIB will indemnify the victim in respect of the loss and damage caused. So those matters that you have to satisfy the MIB of are simply, and again, this is very truncated, that the insurer, so you're essentially going to have to prove liability and quantum. And then once the MIB is satisfied of that, it will pay out. Okay, now Reg 13, this is where we're dealing with either uninsured drivers or driver where you simply can't trace the vehicle either because they've ran off or didn't notice that they've run over you. So this applies where the accident, again, vehicle in a European state other than the UK or a subscribing state, and the victim resides in the UK, and the victim has made a request for information under Reg 9, paragraph 2, and it's impossible to identify the vehicle alleged to be responsible, or within 2 months after the date from the request to identify an insurer for that vehicle, then the victim can claim compensation from the compensation body, again, the MIB. The MIB shall compensate in accordance with Article 1 of the second Motor Insurance Directive. And that's that really. So again, that's those, it can be quite daunting, this MIB issue, but it's really just those 3 regulations, 11, 12 and 13. And you'll know which one it is really if you know who the insurer is or if it's a hit and run. What law applies to MIB claims? Just check how we're doing for time. Okay. So recent Supreme Court case of Moreno and I've written that twice, Moreno and the MIB. Essentially, there was some confusion before this, and the Court of Appeal had thought that English law would apply because you're bringing a claim against the MIB in England. The Supreme Court disagreed in Moreno and said that the point of the Motor Insurance Directives scheme was, it was really just about making the mechanics of bringing a claim much easier because you could do it all within the one jurisdiction, but it wasn't to put you in a better position than you would have been had the driver been insured by giving you higher damages under English law or different damages than you actually deserve. So they held, this was a claimant who was injured in Greece, driver drove off, was never identified, and the Supreme Court held that simply what these regs do, these 2003 regs do, is they enable UK residents to claim damages here as if they were doing so abroad. So thank you very much for your patience and staying awake during that filling tour of the 2003 regulations. It sounds quite technical and tricky, but actually there's only 3 regulations that you need to read, and it's all quite straightforward. I'll just see if there's any other questions.
Yeah, we've got Georgious, who is our resident Greek expert, has pointed out that it's 5 years for insured and insurers and tortfeasors. So you've got 5 years in Greece now. But he also points out, importantly, that in order to interrupt limitation, you've got to issue and serve. And I've been caught by that in the past, where my solicitors have issued but they haven't served within the relevant Greek limitation period. And it was a Greek case with what can only be described as disastrous results. So George is quite right to point out that in some jurisdictions, you have to serve, and you have to serve properly within the framework of that particular jurisdiction within the limitation period. It's not enough to issue. So whereas in England and Wales, you issue within the limitation period, it's fine. You can serve 4 months afterwards. In Greece, it's not fine. So you have to do both. And as I recall, serving in Greece is quite tricky as well. The rules are sort of slightly counterintuitive for an English law.
So it's a reminder just how important it is to have good a good go-to lawyer in these different jurisdictions that you can immediately, check up on these kind of changes. So Georgious is a good man to know for claims in Greece. You'll have to get his number for your holiday in Greece next week, potentially.
That's why they don't really have cars on Ithaca, so it's fine.
Georgious has asked another question. Interest is a matter of English or foreign law. So I'm actually I currently have an appeal going to the High Court now about this, where essentially in Spanish law, you've got a very interesting piece of legislation which says that if an insurer doesn't pay out within, I think it's 3 years, suddenly a penal rate of interest kicks in at 20%. And obviously there are important substantive Spanish policy objectives behind that. Now, in any case where English courts are looking at interest, they're usually looking at Section 35A or the County Courts Act, which gives those provisions that the court may award interest. That, because it relates to a remedy, and there's no automatic right, and the court has a discretion to award. I'll try not to put too many people to sleep, but generally it's regarded as a sort of as a procedural matter, and therefore as a matter of English law. But then there's a fairly recent case of Legat, and where Mr. Justice Legat, I think he's not in the Supreme Court, gave a judgment distinguishing between discretionary rates of interest as to remedy and substantive rights to interest, which may exist under foreign law. Matthew Chapman's just had a very similar case. I think it was just a few months ago, where I think the issue has been decided, hopefully in our favour. I'll try and I'll try and add that case to these slides when we send them out to you. But essentially, whether interest is I won't go into it in too much more detail, but essentially whether interest is a matter of English or foreign law will depend whether it's a discretionary right, well, not a right, but a discretionary procedural matter as to remedy, or whether there's a substantive automatic right under the law where there's no discretion, in which case it would be a substantive right. So you can't say interest is just substantive or procedural, because it depends on the discretionary nature of the right. But yeah, very good question, Georgious. Right, so that's all really, unless there's any other questions. We've got next week Zach Bredemere and Richard Sherry speaking on a property issue, disrepair and dilapidations. These two guys are the sort of Chambers gurus in terms of property. If I ever get a particularly tricky property matter where I need a second opinion, then those are the guys I'll call. So it's really worth checking in on that if you or anyone in your departments do any property work. Hold on, we've got another.
Don't forget, the week after is me again.
Yes, so don't worry that you're gonna you'll get your weekly fix of Sarah in 2 weeks' time again. If anyone's worried about that. We've got one more question from Darius.
I'm worried about it, Conor. They worry night and day. Thanks, Sarah. Not only do they get round up from me, but they get me every other week at the moment with webinars. No, the week after, Jatinda Paul from Owen Mitchell is coming to talk to us about Griffiths and Toohey, which is probably one of the most important decisions this year, certainly the most important decision on gastric claims. So that should be quite interesting. I hope to tempt him into saying something indiscreet about the defendant there. So we'll have to wait and see. But oh, look, lots of questions coming in. Here we are.
I've got 2 more questions. Darius living up to his reputation.
Oh, Darius, no. I managed to get through an entire webinar without asking.
In the interest of maintaining my infamy, would you care to comment on car hire or a motorised tour arranged by a cruise line's excursion department on the ship? Or before the cruise
why Darius is
begins.
so popular with them.
Often claimed by cruise lines in their terms and conditions as not being a part of the cruise and the cruise line not being an agent of the entity in question. I think that would depend.
I wish I'd said that to Darius in the past. I think the is if you arrange it, if the cruise line arranges it on behalf of the holidaymaker, it depends quite how they do it, but they're either going to be acting as an agent for the car hire company or as an agent for the holidaymaker, depending on how they present it. So Darius, I know that's a slight cop-out. I might think about that as another article to do, because every question you ever ask me ends up in me doing a sort of 3,000 word article on things, but it's not straightforward. Agency matters in this country are really murky, as Conor knows, because we've done a number of these cases where sometimes an agent is acting as agent for the consumer, sometimes an agent is acting as agent for the supplier, and it's not at all straightforward, and it depends how they do it. But I think the cruise lines would be saying, we act as your agent for these purposes, we just do what you tell us to do. So we just facilitate an introduction between you and the car hire people. But I don't know what, at the risk of inviting further questions from Darius, I don't know what claim would arise as a result of that, because the cruise line is not going to be the provider of the car hire, clearly, because we know that there's another supplier involved. So unless the consumer had a complaint that it wasn't a reputable company or something like that that was used, they're not going to be vicariously liable for anything that happens. So I think I might be able to weasel my way out of saying that by saying that you're not really going to get a claim arising out of anything substantive there, unless you have one, Darius.
And lastly, a very interesting question from Ruth Graham. In relation to coach accidents, if the ticket is bought in England but the accident occurs abroad, does it affect things? I suppose it depends whether it's the tortfeasor is the driver of the coach, in which case you've probably got a contractual element in there, or whether you're just in the ordinary position of the third party being the tortfeasor, the second vehicle, in which case you're suing in tort.
Yeah,
What do you think, Sarah?
Things jurisdictionally, in that it would give you an additional jurisdictional gateway, because if it's a consumer contract, it's going to be governed by English jurisdiction. So it would give you an additional way of bringing the driver within the jurisdiction or the insurer within the jurisdiction. But you don't really need that if it's European anyway, so that's fine. It might mean that English law is the applicable law, depending on quite how the contract was done, and what the terms of the contract are. So it might affect the applicable law, I suppose, which in turn will affect limitation, because that's governed by applicable law. So in a real sort of barristerial way, we're both saying it depends, I think, aren't we?
Yeah, no, quite an interesting situation. And then just one further question from Richard Estiliano. Is correct service under the EU's Insurer Force Directive REP performed where you serve on the address given by the MIB on its website?
Will this be true if the insurer has changed name since date of accident and date of service? Oh, well, if they've changed, to answer the second question first, if they've changed name between date of accident and date of service, as at date of issue, you sue whatever the current name is, and you just put formerly known as. So you put, I don't know, Alliance whatever, formerly known as Alliance this. And that just covers both. So that's belt and braces approach. And, you know, no one can object to that. If they've changed name between date of issue and date of service, that's fine, because it was okay at the date of issue. So you just serve. You use the address. Is it okay if you serve on the address given by the MMB on its website? I actually don't know the answer to that. I imagine it would be. But I don't know whether that automatically leads to deemed service or whether you have to undertake your own inquiry. Seems unlikely, but I don't know the answer to that, I'm afraid.
Okay, well, I think, yeah, we've been going on for 50 minutes now, so I think we've, you've been very patient with us, and we're very grateful.
Georgious has got another question, which actually, in light of the fact that he's given us guidance on Greek law, we really ought to make time for him.
Oh, yes, yes, yes. Right.
Any more
So,
time?
George's
Pandemic
question. I
accidents.
I do not know if there's, yeah, I'm facing a pandemic of accidents where dodgy quad bikes driven by English nationals suffer broken steering rods. Can this claim be brought in England under the consumer contracts provisions?
Usually I would bring a claim because quad bikes on the road are going to be covered by motor insurance. So you don't just bring a claim against the insurer. But yeah, you could do if you, you could do, which is
Yeah,
the contractual gateway that I was talking about previously.
yeah.
Actually, I've had a lot of quad bike accidents lately, but not broken steering rods. People sort of driving themselves off the road or being driven off the road.
I suppose there's a product liability element in there as well, which makes it more complicated and gives you more options. Yeah. Yes, possibly, Georgious. Yeah. It's a very good question, but I need to go through my sort of consumer contract regulations again before giving a reliable answer. Yes. So, question. Yeah. In terms of recording, yes, this should be up on our famous YouTube channel. I think, and we'll send out slides later on today.
I think Emma sends a link as well, if I'm not much mistaken.
Yes, I think that's right. Yeah.
Okay. Any more questions? Honestly, it's supposed to be back to basics, and yet the questions we've had have been not back to basics at all. I wish I got Matt Chapman involved.
Yeah.
Right. Right. Well, thank you for coming.
Yeah. Thanks, everyone. Have a great weekend.